So one of the questions we get asked all the time by clients is, what is the pretrial conference? So Murat, can you tell us what is a pretrial conference? And in our view, what is it that lawyers do to set up their clients for failure at them?
Right. So the pretrial conference is typically the second date that is scheduled in court following the arraignment. So issues of bail have been established. You've been given the preliminary discovery, and more importantly, your attorneys have been given the preliminary discovery, so they know sort of the basic sketch and the outline of the book. It's like if you go to a bookstore, you pick up a book, you read the back page, and it gives you a summary of what's going on. So, in terms of your involvement and what is going to happen at this stage, you're basically going to just be, again, waiting around, because court a lot of times is really just a waiting game. So maybe bring a book with you. But your lawyer behind the scenes has done some work before the pretrial conference and is going to execute a plan. Hopefully he has one in the pretrial conference stage. Every case is different. There's no sort of cookie cutter solution to the pretrial conference, but I'm going to talk a little bit about some of the ways that lawyers fail to take key opportunities to stack the deck against the government during the pretrial conference phase.
And one of the things that we do is we look at our case and we decide, okay, what is it that the government needs to prove in order to advance this case, in order for the government, the prosecutor, to win at trial? Both Murat and I are previous prosecutors. We've got tons of experience, years of experience in how do we bring a case from the prosecution perspective. So we use that experience and we try to find, okay, what are the difficulties that they're going to have to do? And we ask for those things to be accomplished in the pretrial conference report. This report is not just a piece of paper. It's an agreement between the government and you, through your attorneys, about what the prosecutor has to provide. So when we ask them to provide things that they may not be able to achieve, we can get evidence excluded, sometimes cases dismissed, for the government's failure to live up to that promise.
Right. The promises in those agreements are enforceable by the court. It really is sort of a way for us to set up the government to fail in its ability to prosecute the case through sort of careful planning and meticulous preparation. We're putting rakes down on the ground for them to step on and knock the file out of their hands, essentially. So basically, setting up all these obstacles for them to have to surmount. Eventually, they're going to trip and they're going to drop the ball, and we're going to then bring the ball across the finish line.
One of the reasons that we think people should be represented by attorneys like us, if not us, is that we don't have that one-stop shop approach. We're not saying, okay, we're going to request everything under the sun in a pretrial conference report. There are some cases we don't request anything. Why? Because we don't want to alert the prosecutor as to the harmful evidence that they may be able to get. So we can't count how many times we've shown up for trial on cases the government has then realized that day, oh my goodness, I don't have this crucial piece of evidence and I can't go forward. And that's because we did a careful job of making sure that we get what we need and we don't let the prosecutor know what they don't need to know.
A lot of lawyers, what they end up doing is helping the prosecutor build the case. Make sure you produce the forensic examination of the firearm to prove that it works properly as required under Massachusetts law.
My client has previously been convicted of driving under the influence of alcohol. Can you make sure to get me those prior certified convictions so you can prove it? It's ridiculous.
What they're doing is setting up a checklist for the police and the prosecutors to build the case against you. What we're going to do, and you got to know your audience, you got to know your courtroom, you got to know the DA that's involved with the case to know, the tailored approach how to handle it, because some prosecutors already know how to build the case. So what you do in those situations, or what we would do in those situations, is make sure that we're aggressive and inundating them with discovery requests so that they're going to end up failing to comply with court orders and draw the ire of the judge. But the other prosecutors who have no idea what the evidence is that they need to put their case together, we're not going to ask them any questions, resulting in oftentimes a dismissal of the case against their client on the trial date.
Either way, we're going to make sure that we are prepared and we're going to do everything we can to get what we need for the government, not alert them to any of our defenses, and that's the reason that we have a history of winning.
Right. Preparation and experience matter.